Happy New Year and welcome back to the Privacy Corner from Robert Bateman and Privado.ai. Now this week I'll be talking you through the Italian DPA's fine of OpenAI, 15 million euros. It's been a long time coming, so we'll look at the background here and how ChatGPT got OpenAI in hot water. The California Privacy Protection Agency has published its second batch of settlements with data brokers under the Delete Act, and there's a deadline coming up soon if you want to avoid their fate in California. And Google has planned a controversial change to its policy on fingerprinting. We'll have a look at what the ICO has to say about that. But before we start, let me tell you a bit about Bridge 2025, a technical privacy summit put on by Privado.ai, the sponsors of these videos. This ran last year. It was a great event. They really look at how to bridge the gap between privacy professionals, engineers, lawyers, trying to bring it all under one roof. Some real practical sessions. I'll be involved in two panels, one about adtech privacy risks and enforcement risks, and the other about the regulatory landscape for 2025. So February the 5th to the 6th this year. Hope to see you there. So first up, this 15 million euro fine of OpenAI by the Garante, the Italian Data Protection Authority. As I mentioned, this has been a long time coming. So let's have a look at a bit of the background. Now it starts in March 2023 when there was a relatively minor data breach involving ChatGPT. Some people's chat histories and partial payment details were exposed, but this drew the Garante's attention to what it perceived to be wider GDPR violations on the platform, and it resulted in a temporary stop processing order. These are quite rare but very powerful instruments available to data protection authorities, and basically the Garante said you may not process personal data of anyone in Italy in relation to ChatGPT temporarily while we figure out what's going on. So OpenAI understandably withdrew the service from Italy for that time, much to the upset of some Italian users, but they had resolved these issues by April, the following month. Some of the issues, that is. They said that they would undertake certain obligations at a later date. They published a privacy notice, pretty basic stuff there, OpenAI, but they said age gating, age verification, these things are too difficult, we'll do them later. So in May, they undertook another of the obligations imposed by the Garante, which is an informational campaign via Italian media, telling Italians how it uses personal data for training purposes. This is an obligation really arising out of Articles 12 and 13, 14 GDPR, the transparency obligations. The Garante was not totally happy with how that informational campaign went, and it does come up later on. Later that month, in May, OpenAI also submitted a plan to implement age verification process by September. And in September, September 2023, that is, they engaged Yoti, a UK-based age estimation company, to scan users' faces and verify their ages along with ID and other documentation. So in November 2023, the Garante was clearly still not happy with OpenAI's progress. They had done quite a lot. There are new privacy settings, a privacy notice, some sort of age verification, but the Italian DPA was still not happy. And in January, it announced it was initiating formal proceedings against OpenAI for its alleged GDPR violations. The OpenAI defended itself in March, and then in November, the Garante went one step more formal, as it were, issuing an investigation, its findings, and some last resort measures for OpenAI to save itself from formal enforcement. This didn't work, so we have now the 15 million euro fine. The specific provisions that the Garante says have been violated here, some of these are ongoing violations, some of them are kind of partially or fully resolved, but they cite Article 5.1a, so lawfulness and fairness and transparency principle, 12 and 13, the transparency obligations, Article 24 GDPR, which is a slightly funny one, just imposes a general compliance obligation on controllers. Article 25 GDPR, data protection by design and by default. This is kind of specific to the age verification stuff. The Garante does not consider that ChatGPT is designed with data protection at its core because of the age verification issues in part. Article 33.1 GDPR, which is about data breach reporting, so that minor data breach I mentioned earlier, and Article 83.5e, which alleges that OpenAI did not comply with the DPA's requirements. So there's a €15 million fine and also some obligations. They have to do another awareness raising campaign about their tendency to train their AI on personal data. They have to publish a new privacy policy, and they have to have another go at their age gate mechanisms. This is, as I've said many times, a really tricky thing, balancing privacy and age verification. Not an easy task. Finally, there are some restrictions around how they use personal data for training purposes. This might tie in with the EDBB's recent opinion on training large language models, but that was not in place at the time of these violations or the investigation. Next up, the California Privacy Protection Agency has announced 2 further settlements with data brokers that have failed to register with California's data broker registry. The 2 in question are PayDae Inc., trading as Infilion, and the Data Group LLC. So this is the second batch of settlements under this law. In November, we had Growbots settled for $35,500, and Uplead settled for $34,500 for failing to register for certain periods. And they also have to pay attorney fees and costs. And there are some injunctive terms as well. I'm not sure what they are. The CPPA doesn't seem to specify that. So the Delete Act is basically a registration requirement, but it expands the types of information that data brokers have to provide, and also, I think, amends the definition of a data broker so it applies more broadly. There will be very many data brokers that are not registered, but we now have 4 settlements under this law, and it hasn't been in effect long, so that suggests the CPPA is quite active in this area. If you think you might be a data broker or one of your clients or whatever, you have until January 31st to register for your activities in 2024. And there's a fee, $6,600. The $200 a day fine is probably not going to break the bank for most large data brokers. So if you don't register, you have to pay $200 a day. But again, there are injunctions available to the regulator too, and you're also putting yourself on the regulator's radar. They are obviously actively searching for data brokers that have not registered, and it might reveal some broader issues with your operations if you fail to do so. Finally, Google. Now, this story is kind of part of the Privacy Sandbox saga, but not necessarily. Google is removing a policy that prohibits customers of its adtech products from fingerprinting. So that is using device information and non-cookie type data to identify individual users from what their devices the signals sent from their devices. This has long been prohibited to Google Analytics customers, so you're not allowed to fingerprint people using Google Analytics. But for whatever reason, Google will now remove this prohibition and effectively allow fingerprinting from mid-February this year. Now, this is, as I mentioned, probably in connection with its Privacy Sandbox project. So it's moving towards more sort of confidential advertising processes, but it's facing pressures from 2 types of regulators, and these pressures are kind of conflicting. So we've got data protection regulators who are generally approving of Privacy Sandbox stuff, a lot of which is about preventing fingerprinting because it's probably better position for data subjects and privacy than the current status quo. And we've got competition regulators who are actually not that keen on these initiatives because they threaten to further consolidate Google's market power in the advertising industry. So by removing this prohibition on fingerprinting, we could see advertisers turn to fingerprinting as an alternative to third-party cookies and other tracking activities that are actually less privacy invasive, I think, than fingerprinting, which is really hard to avoid from the user's perspective. The UK's Information Commissioner's Office has come out against this move. I haven't seen anything from any other regulators. It says, our response is clear. Businesses do not have free rein to use fingerprinting as they please. Not terribly clear, I would say. I mean, are they allowed to do it or not? Essentially, you're not allowed to do fingerprinting under the e-privacy directive, at least, and the UK's national law based on that, unless you have consent. Consent for fingerprinting. Is it still fingerprinting if you have consent? That's another kettle of fish. But the ICO has said it will take action if companies do fingerprinting in a way that's not transparent and lawful. Now, we can be a little bit skeptical of this claim because the ICO has never taken action in this area, cookies or adtech per se, let alone fingerprinting specifically. But it's interesting that they have come out against this move quite proactively. So thanks so much. That's all from me this week. Hope to see you at Privado.ai's Bridge Summit next month. And I'll see you next time.